What if the beneficiary is a minor on a TOD deed? Have you ever wondered what happens if a minor is named as the beneficiary on a transfer on death deed? This situation can be a bit tricky, so let's break it down. When a minor is designated as a beneficiary, there are specific rules to follow. Minors cannot legally manage real estate or hold title on their own. This means that while they can inherit property, they cannot control it until they reach the age of majority, which varies by state. To address this, the property owner should appoint an adult custodian or trustee. This person will manage the property for the minor until they are old enough to take control. A common approach is to use the Uniform Transfers to Minors Act. This act allows the adult custodian to handle the property on behalf of the minor. The transfer on death deed can clearly state that the adult is acting as custodian for the minor. It will also specify the age when the custodianship ends, which typically ranges from 18 to 30 years old, depending on state law. This method is beneficial because it avoids the need for a court-appointed guardian. It also simplifies the process by clearly identifying both the custodian and the beneficiary on the deed. However, it is important to remember that the rules governing custodianship are determined by state law and cannot be changed by the property owner. If a custodian is not named, or if the deed simply lists a minor without any management plan, the property may require court intervention. This could lead to the appointment of a guardian or conservator to manage the property until the minor reaches adulthood. Such a situation can result in delays, additional legal costs, and complications in the transfer process. Due to these potential issues, many estate planning professionals advise against naming minors directly as beneficiaries on transfer on death deeds without establishing a custodial arrangement. Instead, they often recommend creating a testamentary trust or a contingent trust in a will. This can provide more flexible management of the property tailored to the minor's needs until they reach an appropriate age. In summary, if you name a minor as a beneficiary on a transfer on death deed, it is essential to designate a trusted adult custodian under the Uniform Transfers to Minors Act or similar state law. This ensures proper management of the property and helps avoid court involvement, aligning with best practices in estate planning to protect the interests of minor beneficiaries.